Good morning, I'm Andrew Fletcher. I'm the new Public Rights of Way and Access Manager, taking over from Chris Miller. I joined in July last year, so it's coming up to my 1 year anniversary at Lincolnshire.
You're very welcome. Just thought it was a golden opportunity for you to introduce yourself. Well, let's move on to the formal business. Do we have any apologies of absence?
Thank you, Chairman. We have apologies from Councillor Sear and Councillor Gibson.
Thank you for that. Do we have any declarations of interest, members? No? Moving swiftly on. Minutes of the previous meeting, held 12th of February. Have we all read them? Do I have a proposer? Very happy to second. All in favour? Yeah, well, that's nearly all of us. That's superb, thank you. And one abstention. Yeah. Right, move on to item 4 then, which is the appeal against prioritization of the definitive map modification order, case 117. Who's going to introduce this? Thank you, Andrew.
So the background to the case. In 1990, the County Council initiated a case seeking to establish if a public right-of-way exists over a 3.1 metre section of High Dyke between the A17 at Bayard's Leap and a point near to Griffin's Farm in Temple Brook with Temple High Grange. So if I could just bring up slide number 2, if that's possible. So on the slide there, it's the red line running from the A17 up to where it says High Dyke, so it's in the north-south section. A formal application was made by the British Horse Society in July 2020, which seeks a modification order to record the restricted byway over the route in question. So the current priority of the case and the original officer assessment, the case, as initiated by the authority in 1990, is ranked 21st out of 479 cases in the priority schedule that are awaiting progression. It should be noted that there are 21 cases currently being progressed and that there are 8 cases which have previously been given higher priority and are awaiting officer availability for progression. The British Horse Society's application, made in July 2020, is linked to the case, but it was not felt that any of the exception criteria applied to it warrant it to be raised in a priority and dealt with sooner. So just a quick thing on the location. So as I've already pointed out, it runs north-south between the A17 and High Dyke near to Griffin's Farm. It's intersected by 2 roads, Temple Road and Long Lane, which are both public carriage roads. If I just move, so that's an aerial photo just showing the landscape. The route is set within the rural landscape and it runs along the Roman road known as Ermine Street, which connected the then provincial capital of London with York via Lincoln. So I shall move on to the next slide. It also forms part of the Viking Way, so that's a 140-mile long distance walking route that runs between the Humber in North Lincolnshire and Oakham in Rutland, and it crosses pretty much the length of the county of Lincolnshire. The Viking Way was developed and promoted by Lincolnshire County Council. All 3 sections of the route have the appearance of a green lane with an unmetalled surface. So from Google Street View, I've taken various photographs at the entry points at each section. So moving on to the appeal. The appeal against the standing of the modification order case in the priority schedule was made by our own Countryside Access and Community Project Officer, following a complaint made by the member of the public about the state of the surface of the route caused by off-roaders. So I've got some photographs which were submitted by the member of the public. So as you can see, it's well rutted in some of these photos. and again there's further rutting just slightly further up, and someone's sadly deposited some rubbish by the side of it. Comparing the photos against aerial photography, we believe that it relates to the middle section, so that's between Temple Road and Long Lane, leading up to what is Cocked Hat Plantation on the map above. The appeal does not seem to meet any of the first of the 7 criterions in the priority policy, but consideration should be given as to whether they meet criterion 8, where the route will significantly assist in achieving a countryside and rights-of-way improvement plan objective or statement of action, as outlined in the Countryside Access and Community Projects Officer email of January 2024. They are Core Task 10, develop long-distance routes and trails. Statement of Action 18, identify and develop circular and linear recreational routes to and from tourism and countryside sites. Statement of Action 19, improve the maintenance and management of routes close to popular areas of the county and key tourism areas. And Statement of Action 20, improve maintenance and promotion of promoted routes and county trails. So as pointed out a moment ago, the route does form part of the Viking Way, which has been developed and promoted by us as an authority. Just as a bit of background, there has been a recent project looking to improve the work. That's included improved way marking, changes to the route to improve safety and access to local facilities, access and surface and access improvements, and information including maps, directions being updated and added to the Visit Lincolnshire website, and the development of new shorter walking routes branching from the Viking Way, including a circular walk incorporating the route in question. So these are routes that will branch off to try and incorporate local habitations and services. So the Viking Way is one of, if not the premier walking route in Lincolnshire, and is itself a tourist attraction. I don't have any counts as to how well it's been used, but earlier this year the website received nearly 10,000 views just on the Viking Way alone. So that tells you how popular it is for people looking to visit Lincolnshire. It's a popular route, and we will be celebrating its 50th anniversary in 2026. In addition to criterion point 8, I should point out that paragraph 3.6 of the priority policy states that the above numbered exception criteria does not cover every eventuality, and it is recognised that in exceptional circumstances there may be other reasons why it should benefit the public for a case to be considered out of normal order. So the County Council's Historic Places Manager has informed that excavations of Ermine Street running across land under cultivation further north to the Cane route have found the remains of the road well preserved in places. So this suggests that in areas where the Ermine Street hasn't been ploughed and remains a feature in the landscape, such as this, it could contain high quality archaeological remains in a good state of preservation. Therefore, any use of the route by off-roaders has the potential to cause damage to any archaeological remains that might exist under the surface. The member of the public who complained about the state of the route informed that some of the ruts allegedly caused by off-roaders were over ½ metre deep, and there's also a lot of rubbish and broken car parts, including a whole bumper, and this was evidence in 4 of the photographs shown earlier. The cutting up of the surface would also make it difficult for members of the local communities and tourists to seeking to walk the Viking Way to use this part of the route. So as it currently stands, only the bottom section, the stretch between the A17 and Long Lane, is recorded as a publicly maintainable highway, and this is highlighted blue in the plan up on the screen. The top and middle sections of the route where the damage to the surface has occurred are not recorded as a public right-of-way or highway. So these sections, so the control of these sections fall outside of our jurisdiction. Should the route be recorded as a public right-of-way by the making and confirmation of a modification order under the evidence-driven statutory process, it may bring these sections of the route into our jurisdiction, and this would enable us to consider what options are available to mitigate damage to the surface of the route and any underlying archaeology to facilitate pedestrian use of this part of the Viking Way. So I've finished.
Thank you very much. As I was saying earlier, as a 14-year-old, I can remember attending a cyclocross that was held on those very roads, and I'm really disappointed to see the state they're in. Do we have any other speakers? Firstly, Councillor Carrington.
Thanks very much, Chairman, and thank you to Andrew for a very interesting presentation. Like you, Chairman, I was horrified to see the state of that. I'm actually familiar with that little bit of stretch of countryside, both driving along the public highway and actually walking occasionally along those routes. The Cocked Hat Plantation on the map just triggered a memory or two there. I'm taking a wild guess here, but I don't think those ruts are caused by legitimate agricultural traffic. And I think there is a point here about segregating pedestrians, whether they're going to and from work or recreational, and horse riders from motorised vehicles. The two do not always mix, particularly in a countryside context. So on that one ground alone, the matter of preserving the fabric of the excuse me, of the right of way, I would support this particular application. I was interested in the 2 points. Excuse me, Chairman. Apologies. I was interested in the 2 criteria which Mr. Pickwell put forward. Criteria 8 as being possibly something we could look at should we choose to go with the recommendation or the appeal rather, and also the business of exceptional circumstances, bearing in mind that we are talking about a nationally significant route for which we are responsible, but at the moment which we do not have powers to maintain. But I was also particularly noting the point made of additional walks which are being considered, which could spring off this, which would fulfill those objectives we've talked about in this committee and elsewhere in this council of generating a joined-up network of footpaths and indeed bridleways and encouraging use, both recreational and non-recreational, of that network. So for all those reasons, and being mindful of the possible routes we could use to justify it, my reaction is to thank Mr. Pickwell again for the presentation and the facts of the case, and to support what we have proposed before us today. Thank you, Chairman.
Are you formally moving it, Councillor Carrington?
Yes, happy to move.
Thank you. Councillor Clark.
Thanks, Chair. It's obvious I'm going to support the application, but what I want is of you, good people, is some guidance. When we sit here and we come up with an application, and that application moves up the scale, can we be in a danger then at a later date of having another meeting with another application and then knocking that first one down that we've already agreed? It just seems like we're going round and round on this, and I know there's supposed to be a long date to when all the applications are dealt with, and I'm not, for 1 minute criticising the council for doing it, but how long will one application be waiting for?
Yeah, that's dependent upon pretty much the evidence-driven process. So there are factors within that we don't have control over. So when we investigate a case, if we determine to make an order, then members of the public do have a right to object to that. And once they initiate that objection, we then have to submit it to the Secretary of State. And that's usually dealt with by way of public inquiry. And equally, if we determine not to make a modification order, then the applicant has the right to appeal that decision. So it's very unusual for a modification order case to go through without objections being made either by a decision not to make an order being appealed or an order made and it not objected to. They most commonly are objected to. So that really does lengthen our timescales, and it's just a factor that we just don't have control over. When it comes to taking on these cases, they do generally go to the bottom of the cases that are awaiting that have been previously prioritised. So there's almost like a mini priority list within that as well. Unless, of course, I think in the last one where it was Addlethorpe, it was felt by the council with that one because I think there was significant threats there that should, in that particular instance, go right to the top. So it was the next case to be worked on, and that has now actually started. So, but in terms of timescales, it's something very difficult for us to provide, just simply because we don't have full control over the process. Okay.
Was that formally seconded? Thank you. So we have moved the motion to move this as a priority case, and I think that's very reasonable considering it's the Viking way, which is something we have promoted, but it is also a good walk as well. So all in favour? Thank you very much. That is clearly carried. Gives Andrew a bit more work to do, but this is just the way it is, and the legal bits around this do make things slow, and it does. I find it just as frustrating as you do, Councillor Clark. So with that, we've reached the end of our business, and I'll bring the meeting to a formal close. Oh, sorry. I haven't closed it then. Oh, moving on.
Our caseload is just over 500 cases at the moment, and we've received about 300 pretty much in the last couple of years.
Do we have the capacity to deal with this process correctly and properly? And that's not questioning the calibre of your skill and understanding, but we haven't got enough boots on the ground to deal with these, which is why we're getting this continuously reoccurring prioritisation, stepping down. Should we be actually increasing our capacity to deal with these, or are we just happy to let them wait? Because as I understand it, if after 12 months we haven't responded, they can go directly to the Secretary of State and we're hidebound to respond.
That's right. So if we haven't determined an application within 12 months, then the applicant has the right to seek a direction from the Secretary of State. In terms of resourcing, Mr. Fletcher might be the better one to answer that question.
Thank you. If I can just coming on there. You're absolutely right. At the moment, the resources are stretched in terms of the amount that we've received. I think it is 62% of our cases are now from one particular source, and they all came in the last 2 years. So each one does take a significant amount of time. What we're doing on that is we've already raised, and I'm talking to my manager, the head of environment, about what we can do resources-wise and get more resource in. I've been working with Andrew to look at how we can streamline the process to make it quicker and easier for the officers that we have to make a decision. Now, we can't control, after we've made a decision, and made an order, we can't control that process as much as we would like because it could disappear up to the planning inspectorate. But we're focusing on trying to get to the point of being able to make the decision and make the order. And then that's as far as we're able to take it on a lot of them. So we're currently looking at some more resources and some more staff for that and just trying to work it through. The new legislation, which sadly is a little bit delayed, but when that comes in, that also allows us to make a preliminary evidential test for all of the existing applications and new ones. That will give us the power where they don't meet certain criteria, and I'm waiting for the regulations to tell me which criteria that is, but that will give us the power to dismiss them without needing to take them any further, and that, I'm hoping, will bring down some of the applications that we've got. It's just a case of trying to do as much as we can because we've been completely swamped.
I've heard what you said, and again, as I understand it, the person who's making his applications on behalf of it's an individual, but representing those two organisations, would be deemed now to be an expert. And the evidence he's submitting from tithe maps, enclosure awards, old ordnance survey maps, is evidentially secure. Because if you look at any one area, you'll see they're discounting some and they're advancing others. We would win and lose isn't right, but actually what they're proposing in many cases makes a great deal of sense, as in this one. But at the moment, they've also said that they wouldn't use that 12-month rule. I think there's an informal agreement between us and them, or they've indicated that they won't sort of jump the gun and use the 12-month rule. Is that true? Do we understand that or not? Or is that the Damoclean sword hanging over us, that their 200 well-evidenced DMMOs could just, if they wait for 12 months, they could just go to the Secretary of State?
It is a sort of Damocles hanging over us, unfortunately. Whilst they can make an agreement that they wouldn't do it, they would still retain the power to do it. We have recently had one in Well, where we've been given a direction, and the timescale that we were given by the Planning Inspectorate was 6 months to make the decision. And of course, once those come in, that messes the whole work plan up entirely as well. So there isn't much answer I can give you than just to agree that actually it hangs over us and we just need to work with them to try and resolve them all.
Thank you very much for the support of the officers. I think that's a real good idea. Ian, did you want to come back in before we wrap up?
I just wanted to pick up on the comments which we've just heard, and I think they're absolutely right to be made. But I just wondered, we are trapped at the moment in ever-decreasing circles because we have an ever-increasing number of these cases being brought. We have finite resource to deal with them. We already have a very, very significant backlog. What we do in this committee is basically move things up or down in terms of the importance, and as Councillor Clark alluded to a few moments ago, if we move one up, by definition, we can't move all of them up. Something else is moving down on the list, and the list is already very long, and there are, I won't call them professional, but there are people absolutely legitimately bringing an awful lot of these to our attention. So my question is, can we examine ways of dealing with this differently? Because it is quite clear that where we are now is not sustainable. We cannot simply apply resource from elsewhere within a finite council budget to deal with this, because that would be resource which would have to come from somewhere else. It's all right for a member to say, can we look at different ways of working? And I'm very well aware that there is a legal framework and probably a practice framework within which we work. But could you comment briefly on what options we do have? And maybe through you, Chairman, we could ask the committee to ask you to look at ways of working either across the board or with individual applicants, for want of a better word, which can somehow streamline a process which is just out of hand.
I think I've asked those questions previously. I think the Act of Parliament went through 2016, and we're still waiting for DEFRA to come up with their guidance. So we are with the next month of fun for everybody. We will be waiting on DEFRA, and until DEFRA do that guidance our officers are stuck between a rock and a hard place. But I would tend to agree with what you said, that if the cases are being prepared that thoroughly by these people, whether or not we could actually use that to speed the things through, but we can't do within the present framework. So it's very difficult, and I'm very supportive of the officers. Thank you.
I thought it might be helpful if I come in and explain what we are doing to streamline. So the current approach has always been to develop a very detailed case report, which would then save time when it gets objected to, because it would become a statement of case, which is another large document you need to prepare for the planning inspector. And I'm aware that you've been involved in rights of way for ages, so I do apologise if I'm telling you things you already know. But what we've been exploring, with Andrew, is what I call the minimum viable product, would be the term you're looking for. We have now got a template report set up. There was already a template, but it's reducing the amount of time that it takes to make a decision. We've gone through the standard evidence list to have a cut-off point where we've assessed as much as we can. We're not going to try and look at every last piece of paper that's ever been looked at unless there's a real need. So we're looking at reducing the amount of time, the amount of evidence we look at, so that we've got, as I say, the minimum viable product, a template report so that they're just not having to write a blank piece of paper. And the other thing is looking at how we're looking at resources to develop evidence packs for the officers, so that they're not trying to they basically can get it all in one piece in front of them, look through and make a decision. So we're aiming to build up the officers so they're able to get about 4 done a year, which is about the national standard. But we're also then looking at mixing the roles so they can do some public path orders as well. So there's a few things that we are looking at to streamline. With 500 cases, there is still a large mountain for us to climb, but we're doing the best we can in that sense. I did like what you were saying about whether we can get the applicant to do, if they are experts, perhaps there's a particular way that they could present their evidence. At the moment, it's just being given to us as a fire hose of information, but there may be some ways of exploring what they're doing there to see if we can shorten it down, certainly with the Ramblers ones.
Quite happy to support them helping themselves and relieving the officers of, and I'm also quite happy with the thought that we've got a process that puts it in an appropriate format for the officers with the technical expertise to do it. That doesn't mean to say they have to assemble the packages themselves. So you could actually streamline it, make them work harder, but I think there is the will within your department to actually get through a lot more of these. So thank you very much. Any other comments? Well, that's a real good meeting. Thanks very much, officers, for your input. Thanks very much, members, for your input, and have a safe journey home. Thank you.